Welcome to this explainer. Today, we're tearing apart the illusion of the perfect contract. You know, those agreements that look absolutely rock solid on paper. They've got the offer, the acceptance, the consideration, the whole shebang. But beneath all that legal jargon, there's often a hidden trapdoor. We're going to dive deep into those very trapdoors today, mapping out the fascinating defenses to contract formation.
And real quick, right off top, this explainer is being created for law office students and also curious minds who just want to know. So if you like this explainer, please like and subscribe. Doing that really helps us keep breaking down these complex legal concepts into clear, visual stories. Okay, let's look at our roadmap. We're breaking these legal escape hatches down into 5 quick sections: our intro to defenses, mistakes and misunderstandings, deceit and pressure, unconscionability and incapacity, and finally, illegality and public policy. Let's get right into it. Section 1. Intro to contracts and defenses, when apparent agreements fail. Right out of the gate, we have to draw a massive line in the sand between two concepts, void and voidable. Listen, a void contract, it's basically a ghost. It never existed in the eyes of the law. Think of a contract to commit a bank robbery. It's a complete nullity from day one. But a voidable contract, that's entirely different. It acts like a totally valid, fully binding contract until the protected, aggrieved party actively hits the eject button. They hold all the power to say, nope, I'm out. Keep that critical distinction in the back of your mind as we go. Moving to Section 2, mistakes and misunderstandings, flaws of the mind. So imagine both parties share the exact same wildly wrong belief about a core fact of their deal. That's a mutual mistake, and it usually means the party getting the raw end of the deal can void the contract. Pretty straightforward, right? But if it's a unilateral mistake, meaning just one party messed up while you're in for a tough time, the law is incredibly reluctant to let you bail on a deal just because you, say, fumbled your math. To escape a unilateral mistake, the enforcement of that contract has to be downright unconscionable, or you have to prove the other side actually knew you made a mistake and actively tried to exploit it. To really wrap our heads around mutual mistake, we have to travel back to 1887 for the absolute classic case of Sherwood v. Walker. Picture this: a cow named Rose II of Aberloan gets sold for a measly $80. Why so unbelievably cheap? Well, both the buyer and the seller were absolutely convinced poor Rose was barren, good for beef, and literally nothing else. But, plot twist, before she's even delivered, the seller figures out Rose is actually pregnant. Suddenly, she's a valuable breeding cow worth almost $1,000. The Michigan Supreme Court had to step in, and the crucial point they made is that this contract was voidable. And the reason is fascinating. A barren cow is fundamentally a completely different creature than a breeding cow. It's like selling a rock that turns out to be a diamond. This wasn't just a minor goof about how much she weighed, it was a fundamental mistake about her very essence. Because both parties shared this massive mistaken assumption, the seller was allowed to cancel the entire deal. Now, what if the parties aren't mistaken about a physical fact like a cow, but they actually misunderstand each other's words entirely? That brings us to the famously confusing Peerless case, Raffles v. Wichelhouse. Here is what went down. A buyer and a seller agreed to ship a load of cotton from Bombay on a ship named Peerless. Sounds incredibly simple, right? Well, unbeknownst to literally everyone involved, there were actually 2 different ships named Peerless, and they were sailing months apart. The seller meant the ship leaving in December, the buyer meant the ship leaving in October. Because neither party had a clue about the other's perfectly reasonable but completely different interpretation, their minds literally never met on a crucial term. The result? Total misfire. No contract was ever formed. Section 3. Deceit and pressure, flaws of behavior. Okay, let's talk about misrepresentation. Fraudulent misrepresentation is pretty obvious, right? Someone just flat out lies to your face to trick you into a deal. But check out that top row. The really fascinating part here is that even an innocent, totally accidental misstatement can make a contract voidable. Seriously, if the false statement is material, meaning it's significant enough that it would convince a reasonable person to sign on the dotted line, and you actually rely on it, you can void the contract. The law's stance here is that you shouldn't be trapped in a deal built on a completely false foundation, even if the other person made an honest mistake. But wait, what about salespeople? They're always hyping up their stuff. Generally speaking, basic opinions or sales puffery aren't actionable. You can't sue a diner for claiming they have the world's best cup of coffee. But there is a hard limit to that rule, and it's perfectly showcased in Vokes v. Arthur Murray, Inc. In this case, a dance studio managed to wring over $31,000 out of a 51-year-old widow.
How? By relentlessly flattering her frankly non-existent dancing abilities. These instructors continuously gushed about her excellent potential, despite knowing full well she had zero rhythm. The court looked at this and ruled that when there is a massive disparity in knowledge, opinions coming from a supposed expert to someone totally uninformed can absolutely cross the line into false assertions of fact. This wasn't harmless puffery. These were highly actionable misrepresentations weaponized to separate a vulnerable widow from her life savings. Now, if flat-out deceit isn't the problem, heavy-handed pressure just might be. We need to be super precise when distinguishing between economic duress and undue influence. Economic duress is harsh. It requires an improper threat that backs the victim into a corner with absolutely no reasonable alternative. Undue influence, on the other hand, is a bit softer, but just as nasty. It's the unfair over-persuasion of a deeply vulnerable person by someone sitting in a position of power or dominance. A perfect textbook example of economic duress is the Austin Instrument case. A subcontractor essentially held a main contractor hostage, threatening to cut off vital radar parts right before a massive Navy deadline. Facing catastrophic penalties and zero backup suppliers, the main contractor had literally no choice but to swallow a massive, unjustified price hike. Pure economic duress. Then you have the Odorizzi case, which perfectly highlights undue influence. School officials showed up at a teacher's apartment right after he'd been arrested and had been awake for 40 straight hours. They leveraged his extreme exhaustion and trauma to pressure him into immediately resigning. They exploited his vulnerability to completely override his free will. Let's keep moving. Section 4, Unconscionability and Capacity, Flaws of Status and Fairness. Let's tackle unconscionability first. Think back to the landmark Williams v. Walker Thomas furniture case. A low-income buyer was sold items using an installment contract heavily padded with dense legalese and a predatory cross-collateral clause. To strike this awful contract down, the court laid out a brilliant two-pronged test. Generally, you need procedural unconscionability, which means the bargaining process itself was fundamentally unfair, like burying things in fine print or stripping away meaningful choice. Plus, you need substantive unconscionability, meaning the actual terms of the deal are brutally harsh and one-sided. Check both those boxes and a court can rip up the agreement. The flip side of fairness is capacity. Look, to form a contract, you legally have to be able to consent. If a party lacks capacity, maybe they're a minor, maybe they're suffering from a mental incapacity, or maybe they are visibly severely intoxicated, that contract is generally voidable at their discretion. Now, there is one big caveat you gotta remember. The law still makes them pay a reasonable value for necessaries. We're talking basic survival stuff like food, shelter, and medical care just to prevent unjust enrichment. But for anything outside of that, they can totally walk away. And that brings us to Section 5, Illegality and Public Policy, Flaws Against Society. This one is all about protecting the public. If the core subject matter of a contract is outright illegal, like hiring a hitman, it's completely void. It's a legal ghost. The exact same logic often applies if an unlicensed professional, say a fake doctor or lawyer, tries to enforce a contract. If that license exists to protect the public, the contract is garbage. Furthermore, even if something isn't strictly illegal, courts will absolutely squash contracts that violate clear public policy. Think about unreasonable restraints on trade, or extreme fine print that tries to excuse gross negligence. When an agreement hits this wall, the court won't lift a finger to help either side. It just leaves the parties stranded exactly where it found them. So let's bring all this home. The next time you're staring down what looks like an airtight contract, you really need to ask yourself a fundamentally different question. Are you just blindly looking at the offer and acceptance that bind the parties together? Or, knowing what you know now, can you spot the hidden legal escape hatches, the mutual mistakes, the dark shadows of economic duress, or the microscopic print of unconscionability that might just set them free? Because honestly, that's how you really read a contract. And that wraps up our explainer. Like we mentioned at the start, this explainer is being created for law office students and also curious minds who just want to know. So, if you really liked this explainer, please like and subscribe. Doing so helps us keep making these for you. Thanks for hanging out and keep your eyes peeled for those legal escape hatches.